Okay, so welcome everyone, and welcome to our first Basque Free midterm recap session. My name is Laurent. I'm the Basque Free coordinator of the EHL recap team, and I will just give you a small rundown of our committee and what we exactly do. So we post free content during midterms and final exams, and we organize Q&A sessions like tonight's session to prepare students for their midterms and their finals. If you wanna if you wanna find our content and our material to prepare yourself for your midterm, you can check out our Instagram, and there's a link in an there you can find a link there for our website. Since this semester we are officially an EHL committee, so everything we do is made by students for students. But please do know that if you would fail your exam, we're not accountable for that. Um, all our sessions are given in English, but if you have some, if you're in the French section, you have some questions in French, we have some tutors available who also could answer your questions in French. I'm going to pass on the word to Eva now, who has been preparing this tutoring session for the last couple of weeks, months. So Eva, here you go.
Okay, hello. So my name is Eva. I'm gonna talk a bit about legal challenges today. Because this is a recording, what I suggest is basically that you use the first half of this recording to check if you know everything in terms of content. And then I suggest you do the exercises and come back to see if you could solve the exercises correctly with me. So wait, let me share my screen. Okay, can you see presentation on?
Yes.
Okay, so just a moment. Okay, so yeah, as I said, basically the first part is just kind of a study guide, because if you look back at the classes, we did a lot of case studies. So maybe you don't exactly remember what we did really in terms of like content, right? Class material. So I'm just gonna summarize it for you. So we have four main topics that are going to be in the midterm. The first one is just introduction to law, nothing special there. Then we've got contract basics, different types of legal forms, or basically business types, and IP, so intellectual property. And to look at it more in detail, so introduction to law, it's really quite easy, right? So it's just, what is legal risk? Why do I need to care about it as a manager? How can I interact with my lawyer? How can I understand my lawyer? And then we've also got differences between different types of risk. And I think this part is a bit more technical. So really make sure that you've got this down, like what are the different types of law? Then we've got contract basics. So here we talked about a lot of different things, right? So different types of contracts, the 6 conditions of validity of a contract. You need to be able to explain terms like meeting of the minds, lack of general consent, what happens when there's a breach of contract, how can it be solved? And some important clauses that we mentioned would be, for example, force majeure, liability clauses, dispute resolutions, attrition, payment clause. So make sure you know these. Then we've got different types of legal form. So here we've got sole proprietorship, partnership, corporation, LLC. Those are like the big four. So you need to know them and what are the differences. And I'm pretty sure there's going to be like some kind of question where there's probably someone who wants to start a business and you have to advise like what kind of business form is best for you. So yeah, really make sure you've got this down and what the advantages and disadvantages are of each company type. And then again, for that, you need to know some definitions like the business judgment rule or the corporate veil. Then we've got IP. So again, 4 types of IP, okay, trademark, copyright, patent, and trade secret. Again, you need to know what they are, of course, and then connected to that are the confidentiality clause and the non-compete clause. So make sure you know what these are and why they're often included in contracts. And then we talked about mark infringement and basically dilution by blurring and dilution by tarnishing. So you need to know these as well. And what I kind of did, so you can use these questions here. I wrote a lot of questions and you can actually use these to test yourself or maybe to test a friend or a study partner, whatever, to know if you are really comfortable with the content. And the easiest way to learn is actually to explain to someone else or to explain to yourself even. So you can use these questions to do that. So I'm just going to read them to you. So, for example, can you explain the difference between civil and criminal law, the 6 conditions of validity for a contract, the remedies for a breach of contract, the 2 types of liability clauses, the dispute resolution clause, the different business forms and their advantages or disadvantages, when the corporate veil is pierced, how the business judgment rule protects managers, and the 4 intellectual property rights. And we've got some more over here. Can you explain why most companies add a confidentiality clause and a non-compete clause to their employment contract? Can you explain when something can be copyrighted? For example, can an idea even be copyrighted? And similarly, can you explain when something can be patented? Can you explain the fair use exception? And connected to that, can you explain the fair sale doctrine? And can you explain the difference between dilution by blurring and dilution by tarnishing? Because there is a difference, but it's quite a small difference. So make sure you've got this down. Okay, and what I did for the second part, or actually, Laurent, you want to ask questions now? You want to ask now or at the end?
I'll ask at the end.
Okay, so what I did for the second part is that I went through all the mock exam quizzes on LMS. I really recommend all of these because I think that's like the most effective way to study. And I always picked like some difficult ones that, okay, so the first question. Mrs. Stern alleges that on September 15, 1995, while she and her husband were guests at the Ritz, Stern made arrangements to receive a massage in the hotel spa. A female attendant took Stern to a small room with a table and told her to disrobe and recline on the table under a sheet. After the attendant left the room, Boris Tanev, the physio, entered, made small talk with Stern, and began the massage. Boris Tanev then sexually assaulted Mrs. Stern, who managed to escape and run out of the room. Mrs. Stern immediately informed the hotel manager of the assault. And here we've got an important clue, okay? Please note that under US law, although specific laws vary by state, sexual assault generally refers to any conduct in which the offender subjects the victim to sexual touching that is unwanted and offensive and qualifies as a criminal offense. So the first question we've got here is, which branch of law is relevant to this case? Is it criminal law? Is it civil law? Is it administrative law? Or is it civil and criminal law at the same time? So stop here and think about it. Okay, and so the correct answer is the last one, okay? It's civil and criminal law at the same time. And I'm just going to explain why that is quickly. The different types of law, basically you have to imagine it's always about the relationship between you and something else. So what I mean by that is civil law, it's always a wrong that you as a citizen do to another citizen, okay? But that does not mean necessarily that there's a specific law about what you did, okay? Civil law, it really varies like case by case by case by case, okay? And someone who, does damages to another person in civil law, usually they will not go to prison, okay? It does not mean very dangerous to society. It will be something simple, like, for example, a breach of contract, okay? Maybe one person forgets to pay the other person, that would be civil law. Criminal law, on the other hand, it's really all the laws made by the government to protect society, okay? So if you murder someone, that's criminal law. So criminal law is really you against the state law. And then administrative law, it's kind of similar, but administrative law is all the laws made by the state. For example, you're not allowed to drink alcohol if you're under the age of 18, okay? So if you still do that, you're also going against the state, not respecting the law, right? But you're not a criminal. You haven't hurt anyone. You're not a danger to society. So that's the difference. Really, always see criminal law as like, if you break the law, the criminal law, you're a danger to society, okay? For the others, that's not the case. And so the reason why here we've got civil and criminal law at the same time is you need to look at exactly what happened, okay? So what's his name? Boris Tanev, he hurt Mrs. Stern, okay? He sexually assaulted her. So the fact that he, a citizen, hurt another citizen, that's civil law, okay? But also, and here we've got our clue again, that tells us that under US law, sexually assault is illegal. He also therefore committed a crime, okay? Because it is part of criminal law that you're not allowed to sexually assault another person. Yeah? So that's why we've got civil and criminal law at the same time. Then question B, we've got who could take whom to court? So we have a lot of options. So I give it time to think. Let's stop. And then, so the right answer is the state takes the defendant to court and the claimant or his and her family takes the defendant to court. I think if you understand A, you will also automatically understand B, right? So the state takes the defendant to court. Why? Because it's criminal law. So he went against the state, okay? And the claimant or his or her family takes the defendant to court. Why? Because it's one citizen who hurt another citizen, okay? And then for C, what sanctions would the court be likely to request? Again, I think if you understood the questions before, you will understand this. So we've got either fines and or prison, damages, or damages at the same time as fines or prison. Again, because this is civil and criminal law, we've got damages. This is for civil law. This is usually what happens if someone goes to court for civil law. Okay, you really remember this? Like usually for civil law, you don't go to prison because you're not in danger. It's just something specific that you did to another person. So we would probably have to come up with damages for the other person. Okay, and then fines and or prison. That's of course the criminal law part. Again, if you commit a crime on a criminal law, it means that you're a danger to society. Okay, he sexually assaulted one woman. Maybe he will also sexually assault other women. So it's really, you've hurt society as a whole, and this is why either you need to pay very, very, very high fines or go to prison to keep you locked away from society. That's the idea behind it. Okay. Then we've got this one. I think this one is a bit tricky. So Potomac Airlines prints on the backs of its ticket that it is not liable for any injury to a passenger caused by Potomac Airlines. Negligence. Ron buys a ticket and boards the plane. On takeoff, the plane crashes and Ron is injured. The cause of the accident is found to be Potomac Airlines' gross negligence. Please note that an airline is considered to be business that is important to the public as a matter of practical necessity because of the essential nature of the services provided. Potomac Airlines can use the clause as a defense to liability, but will not win. So here you have to say if that's true or false. So think about it. And I think that a lot of people here would have a tendency to say that it is false, okay, and that Potomac Airlines could win because they have included a limitation of liability clause on their tickets, right? Because this is basically what it is. You have to imagine this whole interaction is a contract, okay? Everything that happens here is basically just a contract. And so the airline has limited the liability on their tickets. But that's not enough. And we know that's not enough because we get a clue here. So the clue is, please note that an airline is considered to be business that is important to the public as a matter of practical necessity, okay? So what does this mean is basically when Ron enters the airplane, okay, he has already made a contract with the airline. What is the contract? The contract is that the airline will get Ron to wherever he needs to go safely, okay? This is the main business of any kind of transportation, not just airlines, is that they get their passengers to another place safely, okay? It's like the main clause of the contract. So the fact that they limited their liability here, it's basically irrelevant because they have broken their main clause, they have broken their contract with a passenger to bring them somewhere else safely. Okay, and so that's why in this case, even if they do use their clause as a defense to liability, they will not win, okay, because the airline broke their contract of bringing passengers somewhere else safely. So basically, when you get this kind of question, really look at like what kind of contract is being signed here, right? So any kind of interaction where someone does something else for someone and vice versa is a contract. So yeah, really make sure to read it that way, okay? Oh, we're not gonna stop. Okay, wait. Okay, so here's some questions about it, a bit easier, but I think there could still be some confusion about it. So it's about IP. So the first one is information that may be protected as a trade secret includes marketing techniques, customer lists, offer choices, or pricing information. And so a lot of people here would have a tendency to answer marketing techniques, right? Because a trade secret, we always see it just as the way we do something. So for example, the example we had at class was, I think, the formula for Coca-Cola, right? So that's a trade secret. We don't know how Coca-Cola is made as like normal customers. But it doesn't necessarily have to be something you make. It can be basically anything a customer does, okay? any confidential information of a company. If the company wants it to remain secret, they can deem it as a trade secret, okay? So it doesn't have to necessarily be something that you do. So here, the correct answer is actually all of the choices. So marketing techniques, customer lists, pricing information, they can all be a trade secret. But also, if you look at the question, it really says information that may be protected, okay? So of course, like most companies, they will not necessarily hide their pricing information because it's actually a bit hard to hide. Or sometimes they also share something with partners, okay? So it doesn't have to be a trade secret, but could be. It depends on the company's choice. And then also another question about trade secrets is trade secrets, none of the other answers, cannot be registered, are not a form of property, and cannot be stolen, do not carry remedies if they are taken by former employees. So here, so if you look at C, are not a form of property and cannot be stolen, that's wrong, okay? Trade secrets are intellectual property, so they can be stolen. And then D, do not carry remedies if they're taken by former employees. Yes, we do, okay? So if former employees steal your property, they will probably have to pay damages because they're not allowed to do that, okay? So the correct answer here would be B, cannot be registered, okay? So don't confuse it with a patent. A patent can be registered, and it should be registered actually, but trade secrets cannot be registered. Okay, so this is, I think, the most difficult question. So Peter incorporated e-bikes to manufacture e-bikes as they're becoming very fashionable, both to preserve the environment and to help with exercise and a better health. Peter issued himself a stock certificate for 100 shares at $1,000 each, for which he made no payment. E-bike's balance sheet still shows today the receivable it holds against Peter, as he still owes the money to the corporation, while the balance sheet also shows a share capital of 100K. He served as officer and director of the organization. During the 8 years of its existence, the corporation held all required meetings with due care and fulfilled all other such requirements. E-bikes always had its own checking account, and all proceeds from the sales were deposited there. It filed federal income tax returns each year using its own federal ID. Claire and Sally paid $700K to purchase 150 e-bikes from e-bikes Inc., but the company never delivered it to them. Claire and Sally sued e-bikes as well as Peter personally. So here the question that we basically have is, we get the information that Claire and Sally sued e-bikes, the company, okay? I think it's pretty obvious why we do it, but they also sue Peter personally. And in order to sue Peter personally for something that concerns his business, they have to pierce the corporate veil, right? Because usually a business, this is a corporation. So usually a corporation and the manager of the corporation, or the shareholder, in this case, so the shareholder are two separate legal entities. They're basically seen as two different people under the law, okay? But in this case, because he didn't deliver his service and Claire and Sally are angry, they want to pierce the corporate veil. But of course, we need to find a reason for that, okay? So there's some instances where corporate veil can be pierced, and here they give you 3 examples. So only one of them is true. So basically, you have to find the correct one. So I will read all of them. The court should pierce the corporate veil and hold Peter, the shareholder, personally liable because the corporation had grossly inadequate capitalization. And so to solve this, what you need to do is you take the information you have here, okay? And especially the keywords here, like grossly inadequate capitalization, and you look, where can you find evidence in the text for that? And then for that, also for the text, Okay, even for the text, you need to make sure that you kind of filter out the information in the text. For example, here, the first sentence, like the reason why he incorporated e-bikes and stuff, that's marketing. We don't care about it, right? So we need to focus on the facts. So again, the first fact is apparently the corporation had grossly inadequate capitalization. So let's try to find evidence. And actually, we can find the evidence. It's the second sentence already, okay? So Peter issued himself a stock certificate for 100 shares at $1,000 each, for which he made no payment. And the balance sheet today still shows a receivable it holds against Peter, as he still owes money to the corporation. So that's not allowed, okay? He's not allowed to just issue himself stock he never paid for. I think that's quite obvious. And therefore, the first one is true, okay? So the corporation did have grossly inadequate capitalization, and so they can hold Peter, the shareholder, personally liable for it, okay? So this is true. Now, the second one is the court should pierce the corporate veil and hold Peter, the shareholder, personally liable because the corporation had disregarded corporate formalities. So corporate formalities, again, it's just doing stuff like, for example, shareholder meetings, paying dividends to shareholders, all these things, right? So here, again, let's find the evidence for that. So we actually have this information here, which is he served as an officer and director of the organization. During the 8 years of its existence, the corporation held all required meetings with due care and fulfilled all other such requirements. So actually, this is wrong, because he did follow all corporate formalities. He did regard all of them, okay? So here, this is false. And then the third reason he could be sued here, so the first suggestion we have is Peter violated the fiduciary duty he owes to the corporation and therefore a business judgment rule. He was self-dealing, it directly benefited him. So a quick reminder, the business judgment rule, what it says is basically that a manager of a corporation or a shareholder is allowed to make mistakes as long as he makes these mistakes in good judgment. What does that mean? It means that he's always supposed to keep the company's best interest at heart, okay? He's not making decisions, or the manager is not making decisions for themselves, but for the company. And here, if he violated a fiduciary duty, of course, it would mean that he violated that rule, okay? So let's try to find evidence for that. eBanks Inc. always had its own checking account, and all proceeds from the sales were deposited there. It filed federal income tax returns each year using its own federal identification number. So actually, this is wrong as well, because he did pay taxes, as he should, okay? He did pay taxes, and he never had, the company always had its own account. Okay, so he did everything correctly in terms of financial procedures, and he did not act in his own interest. So here again, we see first one is true. Okay, we could find evidence for that. 2 and 3, we couldn't find any evidence, so it's wrong. So this is really where you have to go about it. If you look at the information, you look at your keywords. Okay, for example, here the keyword is really corporate formalities. Here it is self-dealing, and then you try to find proof of that. Okay. Okay. So here is one last question. So Betty choreographs a dance to accompany City Orchestra's performance of a medley of movie scores. Diane, a dance instructor, distributes copies of a short portion of the choreography to her students. This is most likely copyright infringement, of fair use, legal only on a payment of royalties to City Orchestra, and legal only on a payment of royalties to Betty. Okay, so here, the reason why I picked this question is that I think maybe some people confuse the fair use exception and the first sale doctrine. So let me explain. When you have a copyrighted work, let's say, for example, you buy a book, okay? A book is copyrighted by the author, so everything, because a book is an expression of an idea, okay? So everything is copyrighted by the author. And what happens if you buy a book, either nothing happens, so you just read it and that's it, or maybe you're like, oh, actually, I didn't like the book, I will resell it, okay? And that's the first sale doctrine, so you're actually allowed to resell stuff but you yourself already bought, okay? So basically, as soon as a copyrighted work is on the market and can be bought, it can always be resold. So it is not protected in that way, okay? So it can always be resold. The fair use exception, it's, let's say you're a teacher, you bought this book, and then you really liked one part of the book, and you're like, oh, I think my students, that will really help them for their understanding in class. So you show them just a part of the book for free. It shows them for free, but you're allowed to do that, okay? That's a fair use exception. You're allowed to do that because you're doing it for fair use, you're doing it for education, okay, for educational purposes. So that's kind of a difference. And this is what here as well, this is also a fair use, okay? Because the dance instructor, she distributes copies of a short portion. So this is video of a keyword. It's only of a short portion of the choreography to her students. So for that, she's allowed to do it because she's doing it for education. She's a dance instructor. She would not be allowed to give them the whole choreography, okay? Because she doesn't own the work. So she's not allowed to give it to them for free. She can resell it to them, but not give it to them for free. So that's the important difference really about the fair use and first side doctrine. First side doctrine is really about reselling, and fair use is about giving a part for free because it's for a good reason, basically. Yeah, I think that's it. Wait, Laurent. That's it for me. I think Laurent will have questions, but I just wanted to say before, like exceptionally this weekend, if you have questions and they don't answer you on the forum, because I know they're not that fast, you can also write me an email. Like maybe not at 1 a.m. on Sunday, but I will not answer, but you can write me an email this weekend if you have any questions. So this is my email address.